Hi, everyone. It's Grant Abbott speaking, and welcome to this session. It's going to be a lot of case study work today. I think you're going to find it very interesting. First off, I'm going to look at what accountants and, in particular, tax agents can do under their tax agent exemption. I'll also have a good look at what lawyers can do at the same time as well, because they have they've got a bit more of an advanced exemption in terms of what they can do around licensing and financial products. I'm also going to have a look at a case study where we're going to establish a self-managed superannuation fund. We're going to rely on the accountant's exemption. And then what we're going to do is an LRBA, we're a related party LRBA from the client's family trust to acquire a property. So we're starting to get some pretty in-depth stuff. And then what's happens is a divorce, and we're going to exit the spouse from both the SMSF and also the trust. So it's actually a very, very deep dive that we'll be looking at today. I think that the main thing there is that where we're getting to as professions, and many of you probably have seen SMSF, so that's the Succession, Asset Protection and Estate Planning Advisors Association. This is now up and running. We've got a directors meeting next week for the formal launch, and you'll have an ability there to be a foundation member. And as a consequence of that, complete a relevant course and become a certified succession asset protection estate planning advisor. Now, there's a lot of stuff going on around that, and in particular being placed on the Industry Skills Council as part of the financial services training packages in sway. We'll also be going through an accreditation there from the Australian Skills Qualification Association. So we've got quite a lot of things going on. Ultimately, the course that we've been lucky that, well, for Lightyear, we'll be offering was the first of its kind, much the same as when I first started off the SMSF specialisation many years ago, that we were first before industry standards, which I helped draft, were put in place. We've done a bit of a reverse way this way. We've set down the competency standards, offered them out to various institutions, including Deakin, Griffith, Kaplan, and essentially at this stage, none of the institutions have taken up the offer, mainly because we're at a very nascent stage. They're probably not overly keen on building quite significant courses. For example, with Adelaide University, their SMSF specialist course retails for $10,000, I think. So for that, they're just not, because we haven't got a huge amount of members as yet, we're only just starting, they're not willing to spend the resources. But obviously Lightyear Training Group, with myself, are more than happy to get involved there and bring it to you. So this sort of work that we're doing today is endemic and really the style of the 3-day course that we'll be embarking on the 19th to the 21st of July 2021. So if you haven't put in you can always go to Travis or Geraldine at our office, so Travis at lightyeardocs.com.au, and seek a ticket and get invoiced. If you've got more than one, you get some special discounts on that. But have a look at that. If you go and have a look, we'll send out, when I send these slides out, and also the webinar later on, have a good look. I've done a 8-minute video on the 5 reasons why you must be involved in the course at this present point in time, particularly for those of you who've been following me for a long time. I don't switch horses midstream for any reason. So going from self-managed super funds to this area is a joy for me, and I see the benefits in every day. And look, I've just seen what we've achieved at Abbott Mourly, and how even just yesterday we had one of our great advisors, Mark Egan, introduce me to a clients who'd been to 2 solicitors and nothing was really getting down to that bloodline protection and protecting the next level of family. And I just simply basically went through the Moat and Castle, what we're going to do. It's very simple, and you'll learn that during the course. And effectively went straight to proposal, and they loved it. So again, this is just something that we're to go down the track. But today we're going to have a look at SMSFs and also discretionary trusts as well. So for the first thing is in terms of, I think we've all been hoodwinked for quite some period of time. In 2004, we came around, and the first hoodwink was when the corporations changes were made. The Financial Services Reform Act was put in place, and I remember making a number of submissions there. There was an accountant's exemption in there in relation to self-managed superannuation funds. And it was all a bit up in the air, and really at that point in time, it's very, very strange that when we consider at the end of the day, a self-managed super fund is no different from a family trust. And we don't need to be licensed for a family trust. So why do we need to be licensed for a self-managed super fund? And intrinsically, and this is a really important point that I want to get over to you, and you'll see that because we are going to go into this info 216. So I want to spend a bit of time. This is deep diving that we see that we're really required if you want to step to that high level of being a SPEPA certified advisor. In that instance is that when we have a look at the Corporations Act, and in particular Part 7, it's very heavily driven. In fact, Section 760 of the Corporations Act, which lays out the thematic for that part, provides that as legislation for the consumer. So again, let me just talk about that. The legislation provides details and laws and regulations around protecting the consumer. And that is fairly interesting because when we have a look at a self-managed super fund, and that's going to be indicative when we go down to info 216, that essentially there's two parties that we may well be advising on when we're dealing with self-managed super funds. And I've always argued this case, and it's great now that we've got ASIC arguing the same case. First off is the case where we may be advising a member. So when we advise a member, we might say you can make contributions to super, or you should make contributions to super, so on and so forth. Now, in that, effectively, we are dealing with a financial product because a contribution is investing into a self-managed superannuation fund. Now, the self-managed super fund is not a financial product in and of itself. It's a basket of entreatments or contracts with the underlying members. And as soon as we do with members, we talk about consumers, and then consumers means then the Corporations Act, which means licensing. So, for example, to go to a client saying you're bloody ridiculous being an Australian super or CBUS and you must go and set up a self-managed super fund, that quite clearly is dealing with a number of products. One is telling a client to effectively terminate their superannuation product, which is deemed to be a financial product under the Corporations Act. That is, you're telling them to get out of a financial product, being our Australian super, and then moving into a new one, which is a self-managed super fund. But notice how it is as a member. Contrast this to a person who says, I would like to establish a fund. How do I go about establishing it? And more importantly, you are advising them as a trustee or a prospective trustee to set up that trust, much as the same way as you would advise a client to set up a family trust. And that's important because it's very hard, for example, when you're dealing with a family trust, a discretionary trust, to ever really advise a beneficiary, because in essence, if it's a discretionary trust, it's up to the trustee. So anyway, let's just take this little snapshot, and then I'm going to go into the case study. Then we're going to start to break everything down. So this is straight from ASIC Info 216, and I'll leave a marked up version of this up on our strategy center for you to access. So expect that to be coming out a little bit later today or early tomorrow morning, because I've got quite a few meetings on today. So what it says there is, this is for an accountant, an unlicensed accountant. So we're not talking about a licensed accountant, we're talking about unlicensed. In fact, it's quite interesting when you do go and have a look at Info 216. There's a whole lot of stuff there that's the exemptions I want to show you through and take you through. Unfortunately, if you're an accountant and you're licensed, you miss out on those exemptions. So I think you're going to be really surprised when we do a deep dive today. Anyway, I pulled out this, and I think it's just a good one to really, put it right up there. So the advice you give, again, an unlicensed accountant, about establishing, operating, structuring, or value an SMSF must not amount to an explicit or implied recommendation to establish an SMSF or require dispose of an interest in an SMSF or another superannuation fund. However, we recognise that advice given to a person about the establishment of an SMSF may also carry an implicit recommendation to the person acquiring interest in the SMSF. Therefore, you're more likely to be able to rely on exemption when your client has already made a decision to establish the SMSF before seeking your assistance to take the next steps. For example, you may recommend the best structure for an SMSF to suit your client's situation after they have made the decision to establish an SMSF. So if they come to you and say, look, I want to set it up, then you can go in, and the classic one is, well, what do you mean by structures? Well, all of you on here are quite well aware. If you're not well aware, we'll talk about it as we go through, the difference between our standard light year docs self-managed super fund and our upgraded bloodline style light year docs leading member self-managed superannuation fund. They're two completely different beasts, and you're going to see I'm going to use the standard, but when we come around, you'll see in a case study later on when we do a bit of a review that effectively we probably should have in the first instance set up a leading member fund. So anyway, I'm talking to you as an unlicensed accountant or a tax agent. John and Sally Smith are an Australian super with over $400,000 in superannuation benefits between them. So obviously they've got a financial product interest within Australian super. They've been looking at property and want to use their superannuation to invest in a $600,000 apartment in Avalon Beach in New South Wales. You are their tax agent, and they advise you that they want to set up a fund ASAP to attend an auction in a month's time or make an offer now. As you know, you're probably well aware this happens all the time. You are the agent for their family trust and bucket company, which has $400,000 in cash. You've suggested that the bucket company proprietary limited lend the money to the trustee of the fund to acquire the property, which seems to be fairly standard these days rather than going to the banks. The trustee of their Smith Family Trust is John and Sally Smith. John is the appointor. Now, I'm not going to do a deep dive into the related party borrowings. Just know that if you're a strategist or a licensee, we've got a strategy automation of that for you. Now, I'm going to take a little bit further forward on the timeline. It is now 2023 and John and Sally are getting divorced. Part of the family law settlement are orders to remove Sally from the Smith Family Trust and also the Smith Family Super Fund. But what we're going to do is we're going to start at the start and work our way through there. So what I want to do is we're going to just go straight into the ASIC 106. So g'day, Tim, how are you?
For a bigger band than just 3 years as well.
So let's go down and have a look at...
And if you're apparently a danger to the industry or clients.
So for that one, we've got info 216 is accountants who provide service relating to
Let's regroup later this Savo. Let me find about the insurance. I'll call Worrells and try and suss out what's going on.
Don't you like him? He's just having a chat and then he's oblivious.
Okay, mate.
There we go. So AFS licensing requirements, this came out in 2018. And I don't think any of you have probably read it. In fact, I'm sure not many financial product providers or licensees have read it as well. So let me just see if I can get Mr. Tim up there and say hello, and so he can have a chance to have a chat. So you there, Tim? Oh, Earth to Tim, are you there? No, it's not, obviously not there. So let's go through. So this information is for accountants who provide services relating to self-managed super funds. I'm going to skip through quite a lot of this because a lot of it is just a general preamble and talks about the stuff here. So I've highlighted, earmarked the areas that I believe are appropriate, notwithstanding the fact that you should probably read it all, but definitely. However, there are a number of exemptions from the requirement to be covered by an AFS license, including for accountants providing services relating to self-managed super funds. Hey, Tim, are you there?
Sorry. Yes, I am. How are you?
Yeah, good. I heard you get off the phone. So hopefully it wasn't a confidential phone call. So it's all being recorded, but good to see you anyway.
Yeah, good.
Yeah, so we're just going through info 20, info is at 206, 216. So let's go through. These exemptions apply to a variety of different activities are outlined in Table 1. So we go through the limited licensing. Let's go straight down to exemptions that apply for SMSF services. So these are exemptions for accountants and tax agents. So I'm going to break them down. So the first one we're looking at is accountants, and then we're going to look at tax agents because they are covered quite specifically. So recommending that a person acquires or dispose of an interest in a self-managed super fund is financial product advice and requires you to be covered by an AFS license. Now, notice here, we're talking about members. We're not talking about trustees. It is also financial product advice if you recommend a person should not dispose of an interest in SMSF, they should remain in their non-SMSF superannuation fund and should not acquire an interest in SMSF, because this is financial product advice about a person's existing interest in their superannuation fund. However, there are other types of advice as services you may provide without an AFS license. Now, these are exemptions for you. For those of you who are already licensed, these exemptions in the most part don't apply. So you still have to go through the PDS, you still have to go through doing SOAs, etc. So let's go down, and again, this is from 2018. You can see there it was the 6th of May 2021. We've got there. So type of SMSF service: establishing, operating, structuring or valuing an SMSF, including advice assistance on administrative and operational issues, the process of winding up or exiting an SMSF. You may provide advice on establishing, operating, structuring or valuing an SMSF as long as you give your client the appropriate warnings. This includes advice provided for the sole purpose of and only to the extent reasonably necessary for ensuring compliance with the super legislation, and advice on the process of winding up or exiting a fund. You may not recommend that your client acquires or disposes of an interest in a self-managed super fund, although we will look at that a little bit later on. So that's Corporations Regulation 71295. Now, this one is going to be a bit of a shock for us. Asset allocation investment strategy. You may provide a recommendation, and this is for unlicensed accountants, or statement of opinion on how your client should distribute their available funds among different categories of investments. For example, between 30 to 40% on property, or in this instance, we're building the investment strategy for the self-managed superannuation fund, which will primarily be in cash and property. So we'll be talking about a certain percentage going into the self-managed superannuation fund. And that's Corporations Regulation 71338. Tax advice on SMSFs and other financial products. So this is important. So this is, for example, on shares, managed funds, property, etc., but any other financial product. So you may provide tax advice on financial products such as an interest in SMSF and underlying investments held by the SMSF, as long as you do not receive a benefit as a result of your client acquiring a financial product. So that's, for example, a commission or a financial product that falls within the class of product mentioned in the advice, and you give your client the appropriate warnings. Tax agent and BAS services. So this is interesting. If you're a registered tax agent or BAS agent, you may provide advice as given in the ordinary course of activities of such an agent as reasonably regarded as a necessary part of those activities. So that's a specific exemption, 766B 5C. 766B 5A and B deal with lawyers. So if you're coming from a lawyer, you're able to give advice on these range of things and get an exemption. and there's referral. So let's go through and just have a look at a couple of these areas. I don't want to bog you down, but establishing, operating, structuring of value in SMSF. You may provide advice on establishing, operating, structuring of value in SMSF without an AFS license. So we looked at that regulation. This means that without being covered by a license, you can provide advice on the practical steps that we needed to establish a SMSF. So John's come in, remember John and Sally? Well, this is what you need to do. We need to set up a fund. We need to set up obviously a corporate trustee, blah, 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 blah. How to add new trustees and members to an existing SMSF. The different ways an SMSF could be structured. For example, if we're going down that borrowing route, that we might need a holding trust. And then we talk there obviously between the leading member trust, and obviously also we'd be looking at not only the leading member trust, but also the standard self-managed super fund, and how to process transfers or rollover funds. Assist clients to complete paperwork to acquire securities through an SMSF. Help clients to add new members and trustees to a fund. Arrange to wind up an SMSF on a client's behalf. Now, you can rely on this exemption if the advice is provided to a, remember, trustee, a director, a trustee, an employer sponsor, a person who controls the management of the fund. The advice must be given to the person in their capacity as the person who controls the assets owned by the trustee of the fund, and then or their capacity as a beneficiary or member. So again, make sure when you do your advice that it's targeted. You either, if you're doing a professional letter of advice, that it is as a trustee, not to the client. Where you're relying on this exemption, if your client is a retail client, so this is beyond the trustee, this is going to the member, under Regulation 71295, you must provide a written statement to the client that you're not licensed to provide financial product advice under the Corporations Act, and they should consider taking advice from an AFS licensee before making a decision about a product. So we've got one there for trustees, so really open slather in that one. You can do investment strategies, you can basically do asset allocation. The second one, if you're going through a member, you can advise them, but you need to obviously put the relevant disclaimers. So when we have a look there, so this again is that snapshot we talked about, the advice you give about establishing, etc. So that was right from the start of our presentation. Advice for ensuring compliance with super legislation is pretty obvious. Asset allocation and investment strategy. So without an AFS license, you may not advise your client about their retirement investment strategy. So that's as a member, including whether your client should increase or decrease their contributions into the SMSF, what their overall investment strategy should be for their SMSF, that is what target investment return or what contributions they should make. However, you may provide a recommendation, a statement of opinion to your clients on broad asset allocation within their SMSF. That is what proportion of the fund should be allocated from that. So we can't get into the detailed retirement strategy, but we can do investment strategy and talk about the relevant allocations. So we can see here a lot there, tax advice on SMSFs and other financial products. I want to jump down to tax agent and BAS services because most of you are tax agents. So if you're registered with the TPB as a tax agent or a BAS agent, you do not need a license to be a representative of a licensee to provide advice that's given in the ordinary course of your activities as a tax or BAS agent, which is reasonably regarded as a necessary part of those activities. Again, there's a specific exemption within the Corporations Act for that. So let's go down and have a look here at a couple of examples. Contributions into an SMSF. All of us would say, well, hold on, that smacks almost of financial product advice from what we've seen. However, if we give the tax consequences, for example, if you put in $25,000, it's going to be tax deductible to the family trust, trustee of the Smith Family Trust, then that is a different example altogether. So that would not be caught up. But here, under the exemption, a registered tax agent may provide advice on any tax implications of contributions into an SMSF or other super funds, such as the client's eligibility to make concessional, non-concessional, and the tax treatment of those contributions. For instance, the tax agent can use a client's total super balance to advise the client of the eligibility for the unused concessional cap carry forward, the non-concessional contribution cap, the 2 or 3 year bring forward period. However, they cannot recommend that a client make a particular level of contributions, though they can advise on the maximum level of contributions a client can make. This is because the decision to make a particular level of contributions involves considerations other than tax. As another example, a tax agent can advise a client they will be eligible for a tax offset if they make a spousal contribution, etc. So let's go and have a look at accumulation versus pension phase. A registered tax agent may also advise a client on the tax implication of moving their super benefits from accumulation to pension phase, but may not make a recommendation to a client about when to do so. For example, a tax agent may advise a client of the tax implication of retiring at different ages and transfer of assets. So I won't go through that further, but you can start to see we've got, pretty wide open door there to look at in terms of our exemptions, particularly if we are a tax agent. So what I want to do now is I'm looking straight into our documents, SMSF, establish, maintain, and upgrade. So rather than going straight into our leading member, which you'll see here, there's a whole suite of separate leading member SMSF. I'm going to be looking at a simple SMSF establishment with a corporate trustee. A couple of things is we're undergoing, you've probably heard me before, I was expecting it by this stage in terms of establishment, but we've got Lightyear Docs 2.0, which is coming out within the next 4 or 5 months, which is really going to be completely different to anything that you see at this present point in time. So it's very exciting to look at going down the track. So I'm setting up the fund. It goes into our iframe, and so it's not going to be as ugly as this, I can tell you that. It'll be very glossy and very easy to use. So I've got the Smith Family Super Fund. I put in the logo tag. You can put in your own logo tag, but I'm just going to put in the Abbott Mourly logo. So we're going to go down the general. So the Smith Family Super Fund. So for those of you who haven't done this before, or you've done it before, you're actually going to see, so we're setting it up for the fund. We're going to set it up today. The state that it's going to be in, our clients are in New South Wales. Now, this is a new option you'll see in our leading member and also SMSF establishments. Are you an accountant seeking to rely on the corporation's regulation for a licensing exemption, etc.? So when we go there, we go yes. I think that's important. So we put the name of the firm, and then what we're going to do there is we're then going to put the name of the accountant. So we've got John Jones, who is our accountant there. So let me just get rid of that. The trustee is the Smith nominees, Pty Limited, and then we've got our ACN. So we put our ACN in there. Can you just, Tony, can you just have a quick chat about what we've been doing quickly? Tony, you there?
Yeah, I'm here.
Yeah, do you just want to talk about some of the cases? I've just got to do something for a couple of minutes, so sorry about that. But just talk about how we can facilitate SMSFs if a client if an accountant doesn't want to do it directly.
No, that's fine. All you need to do, guys, is actually, if you don't want to do it, just get in touch with me, and we can have a chat. And the first thing to do, if you want to do it, is we facilitate the interviewing process with the client. We actually get on a Zoom together. I ask them questions surrounding as to why he wants to set it up, etc. And then what happens after that is I send out a detailed letter of advice surrounding the issues of the SMSF. It's pretty detailed. It's around about 10 pages worth. So it's pretty detailed. So it covers the relevant issues when you're setting up the SMSF. And then what'll happen then is basically from your end as an accountant, all you need to do is set up the corporate trustee for me, directors, shareholders, members of the fund, what the fund's name is going to be, what the corporate trustee's name is going to be, and you send all that information across to me, and then I take over basically and I set up the trust deed, etc. And it's pretty straightforward, nothing to it. If there's an LRBA that needs requiring, the same principles apply. Other than that, it's a pretty kosher. So if you need any help in that respect, just give me a buzz or just email me, and I can certainly guide you through that in that process. So yeah, is there anything else that you guys need to ask me whilst Grant's doing something? Anything? There's got to be some questions.
Hey, Tony, it's Tim here. How you doing?
Good, mate. Yeah, I was just asking, so everybody sort of doesn't want to ask questions, you know?
I might ask a question I just spoke to Grant about earlier. Can you just run through with us when we're getting clients to sign wills?
Yeah.
What's the process? Like, do we staple them? Do we bind them? Do we do 2 copies? And where should we keep them?
Okay, cool. Just all you have to do if we do a job like that, you don't staple them. You just put those, you know, the clips to them.
Like a bulldog clip sort of thing?
Yeah, bulldog clip. Yeah, never staple them. So that makes the process much easier, basically. And what will happen after that? Once we set up the Zooms together, we get the clients. We run through the aspects of the will, see if there's, you know, any amendments that need to be done on it, which I'm sure there would be. And then we send it all back. With the amendments, we jump on a second Zoom again to make sure that the wills and EPOAs are correct. And then we take you through the signing process, basically. And after that's been done, the original wills that have been signed come back to me via express post. And then what I do is I sign them off on the day that we actually had the Zoom. And then I send back the original wills with a certified copy of the wills and EPOAs and any other estate planning documents, and the actual original wills and any related estate planning documents actually get distributed back to the client directly with a copy to be kept on file for the advisor also. So it's pretty straightforward. There's nothing to it, basically, you know.
But people can bind it, can't they? So if you had a will, there's nothing wrong with binding it, or does it need to be bulldogged?
No, bulldog. I prefer a bulldog, you know, because then what'll happen if it's all binded up, then you need. I've had experiences before where the probate office has actually said to me, "Well, why have the documents been binded up?" And they give you such a hard time, you know. So it's preferable not to bind them up, but rather have them bulldog clip, yeah, you know. So that way it's more accessible so that you're not sort of stapling and taking staples off, but then you've got to swear an affidavit up and all that stuff. So it makes things a little bit not complicated, but the process takes a little bit longer when they're requisitioning, you know? So,
now, thank you for jumping in, guys. Now, sorry about that. I'll just give you a bit of a backstory. This morning I was doing some work and found a snake. We just moved home, a snake outside my office window. And just as we were going through, my little dog, who last week was in hospital, cost me $1,200 because the dog decided to eat through an electrical cord and got electric shock. Then decided to follow or go out into the bush just then where all the snakes were. So that's why I had to do it. But thank you very much for covering for me. But anyway, I've got a couple of questions here that I'll just do before I have a look. You saw me just complete that establishment of the Smith Family Super Fund with the accountant's letter. So I've got one from Gerard Trapnell, which is great. Is A&M able to register mortgage for self-funded LRBA? And I'm going to show you where that is. No, but we've got Michael Jeffries from Eventum Optimum, and I'll put the details in when we send this video out. He can effectively do registered mortgages, can stamp deeds across Australia. So it's not just in one state, it's all across, and also put things onto the PPSR register. So that's a service that I know Tony and I were working really hard to look at who could do that, because that's not our core competency. But Michael stepped up the plate, acquired PEXA, and effectively is in a position to do that. So definitely do that. There's, if you go to eventumoptimum.com.au, you'll have a look at their services there. John Stidscombe, client has passed away as one of two individual trustees of our SMSF. How do we replace him with another person? The SMSF has two commercial properties that will soon be sold, already searched under Queensland title deeds. How do you update the title deed with a new individual trustee? So that's a really good position. In fact, we're going to have a look at what to do very shortly, John, after this one. But with that one, you can see, you know, from that perspective, obviously there's going to be a change in trustee, so you can do an SMSF change in trustee. The issue about that one is you can see that there's an issue there that if you've got two individual trustees and one passes away, you've got a really, you know, you've got to go through this whole process. So again, John, this is something that you would highly recommend your clients at any point in time to make sure that they have a corporate trustee so these issues don't apply, particularly if you're using our leading member. So here's our standard SMSF trustee. We go through. Now, here's the first thing. Important information about your self-managed super fund. So this goes to the trustees of the Smith Family Super Fund. We refer to your request to establish a self-managed super fund on behalf of you and your family. In that regard, the attached SMSF trustee and governing rules are based on data provided to you by Jones Accountants. Remember how we filled that in? It uses current legal precedents provided by our legal firm, Abbott Mourly, to ensure you have a set of rules that's strategic, modern, provides benefits for you, your family, your bloodline, and can take up to 6 members. We have attached a copy of the SMSF's PDS, which is a broad guide to the benefits and risks of holding SMSF. We strongly advise that you should spend time in reading the PDS as well as the trustee itself to become acquainted with the rules of the fund that we've prepared. One of the authors of the Abbott Mourly SMSF trustee and governing rules is Grant Abbott, who's written a handy guide to SMSFs that you may want to invest in, the Guru's Guide to SMSFs, to further your education. In addition, the Commissioner's got this. So Jones Accountant advice. Abbott and Mourly lawyers have prepared the set of governing rules for SMSF. Jones Accountants, in particular John Jones, who facilitate this process, it's important to note that they are not financial planners nor licensed advisors and did not recommend SMSF to you, but rather you sought the establishment of the SMSF by the firm on your behalf. Importantly, Corporations Regulations 71295D and also ASIC requires Jones Accountants to advise you the following. Jones Accountants is not licensed to provide financial product advice under the Corps Act, and you should consider taking advice from an AFS licensee. Should you have any queries, so on. So that's your accountant's exemption letter that follows on from Info 216 and also Corporations Regulations 71295D. And then I won't go through the rest. The rest is obviously you've got the governing rules of the fund as part of the package. So you've got the trustee, the initial members, so on and so forth. Then we go into obviously all the rules, we sign off, initial members sign off. You'll see here there's no applications in our documentation, mainly because there's no need to have an application unless you're a new member after it's established, because you are signing off as an initial member. That means you're actually party to the deed in itself, so it's a lot stronger. You go past there and you'll see that there's also a whole range of stuff there. We've also got the PDS and the trustee declarations, which are really important as well to give to the tax office when you're establishing a fund. So that's how we establish a fund. The difference between this fund and a leading member self-managed super fund is that with a leading member self-managed super fund, for example, we would have a John Smith as the leading member. Now, as the leading member, John has the power to hire and fire the trustee, a power to hire and fire members or appoint and remove members, and essentially really controls that whole self-managed super fund, because embedded, not in the trust itself, but within the corporate trustee, is that John is the chairman and also has complete veto power. In fact, if you wanted to, for those of you who've been reading my writings in terms of enduring powers of attorney and a new way of running a self-managed super fund, we might in fact have, where we're going, it might have been better to have John as the corporate trustee, the sole director, and having Sally's EPOA, and therefore Sally is a member, but she's not a trustee or director of the corporate trustee, which is absolutely imperative as well. Karen has asked a question, has that letter always been part of the package? No, that's why we're doing this session, is to show you this is a brand new part of the package that we're doing. Again, we're continuing to amend. For those of you, for example, next week we'll look at it. We've got some changes to the protector. If you haven't used a protector yet, you're really well and truly missing out on, I believe, is probably the best strategy around, even better than a self-managed super fund. I would hands down prefer, if I only had a chance to either do SMSF advising or advising on the protector, I would personally go the protector hands down. Next week, we'll be rolling out some enhancements to the protector, which you might have already seen. For those of you who have already completed a protector for a client, you might want to go in and you'll find that there's an endorsement of promissory note attachment to it now, an extra button there, which is crucial. And next week, we'll be adding a call option in there for reasons that I'll explain next week. But there are a couple of variations which are very exciting in that whole equation or the scheme of things. So thanks a lot, Karen, for coming back on that one and pointing that out. So what we've done is we've established the fund. I'm not going to do anything more. I'll just remember we're going to do an LRBA, a related party LRBA. And for that one, Gerard asked a question. To do the related party LRBA, we go into our strategy automations. You'll see there, related party LRBA meeting ATO guidelines. Now, I'm not going to go through that because we want to look at exiting members at this present point in time. So we've got the related party meeting the ATO guidelines. From that perspective, a key requirement is you need to have a mortgage deed which is registered, which then goes on to a venom optimum. So that would be the next strategy I do. In fact, before I do that, I would be putting in place an investment strategy enabling the trustee of the Smith Family Superannuation Fund to invest in property and set that up, then do the related party. So I may even go through and put that in place at a later stage, or certainly up on our strategy centre. So let's go back and have a look at our SMSF because we've now gone in a position that Sally is now divorcing John. Family law court orders require her to exit the fund. So we're going to be member leaving the fund. At some point in time, we will be building, and we're certainly going to start it with unit trusts, and putting all the various actions and interactions and transactions, Sally leaving the fund. We're going to put those all into automation. So virtually becomes an all-encapsulating document portal there. With LYD2, we'll be linking in with both Class Super and importantly, Simple Super Fund 360. So I'm going to put in there just SMSF. Oh, sorry, I'll actually put in AM. Sorry, AM 001. So that's our logo. Fund details. So it's the Smith Family Super Fund. Now, if we need to change a trustee, we would, but we wouldn't in this case. So that's different from the case we had before with John. So I've got Smith nominees. So in that instance, it's much better, obviously, always, because things change, it's always better to make sure we have a corporate trustee. But it's not just any corporate trustee, it has to be a special purpose corporate trustee. And if you're using a leading member one, make sure that you get the leading member special purpose corporate trustee, because once you resign as leading member, effectively the shares are cancelled and the next leading member takes on. So remember, we've got two directors. So we still have here, we've got two directors confirming here. We've got Sally Smith, and then we've got also John Smith. Now, if Sally's already resigned as a director, then we don't have to put her in there, but we'll get her in there. And again, the good thing about it, if we have the leading member, so we've got Sally Smith. Now I'll assume here she's moved out. She's gone out with a tennis coach, whatever she wants. So Manly, New South Wales, 2094. Okay, so reasons for leaving. So we can put their divorce or separation. Tax file number, if we want. Does a member have a legal personal representative? For example, we might be leaving because we're incapacitated or the executor or whatever. So I'm going to put no there. But if you do, a separate thing will come up. So we have the trustee meeting. Again, just select that. That will then pre-complete that form. And you'll see who attended the meeting, both Sally and John. And again, if it's family law, both of those can do it just by way of a phone or a Zoom meeting or etc. So this is the member leaving the fund. So I'm getting rid of Sally. Obviously, you've done all your calculations. And if it's part of a divorce, you'll see you'll get orders that she's to get this, or this is what's happened to this, so on and so forth. But you'll have to exit the fund. So here I've got the exit of her in the fund. I just press the download. And again, we'll probably put in applications, exit, and all encompassing once we've built Lightyear docs too. So that way, when you've got a vault open for a client, much the same for those of you using the Moat in the Castle, we can put everything in there. We might even put it into the Moat in the Castle. So the member leaving, Sally Smith. We then go down. It's a pretty simple document here. Binding resolution, member leaving the fund, Smith Family Super Fund, both directors. Reason for leaving, divorce or separation. The member's leaving the fund because of divorce or separation. In exiting the member from the fund's membership register, the trustee has conferred with its advisors. Note the following will be completed before the member leaves. Determine the member's balance in the fund. Prepare an exit statement detailing the member's balance. Remove the member as trustee or director of the fund's corporate trustee. Ensure the trustee has the correct tax file number for the member in order to notify the ATO of the member leaving the fund. Now, you don't have to do a form if you're a tax agent. You can just go online and do it through the tax agent portal. Notify the member of any loss of insurance. Calculate any, if applicable, pay-as-you-go tax liability in relation to any withdrawal. Pay any super benefits to the account of the leaving member choosing. Should be the leaving member's choice. Notify the commission taxation of the member leaving the fund through one of the following: online, so on and so forth. And then we just go down. So that's the trustee minute for someone leaving the fund. So that's pretty easy. That's pretty important there. If we then go down for that, the next one we've got to do is for the trust. So again, I'll just take you back to show you where we're going. Setting up that particular, remember setting up the related party LRBA, we go to our strategy automations. Setting up or the member leaving the fund, what we need to do is go down into SMSF, establish, maintain, standard SMSF documentation and minutes. And you'll see there, we've got there, we've got member appointment, you saw there, but member leaving an SMSF. Now I'm going to go back and now I'm going to go into the trusteeship, which is important. So with the trusts, I love this one. So again, we're going to go through standard trust and other documents. Most of you should be well acquainted with this because you're going to have to do your discretionary trust distribution minutes. I would suggest you'd want to do those now, getting ready for the lead up to 30 June. But here we're going to have changes to discretionary trust positions and also the name. I love this little section, and we're going to spend the next 5 minutes on this one. So again, just doing the same thing, Sally Smith leaving. So that's pretty easy. We have to get rid of her at that point in time. So we get our new interview session, and then we start working our way through that. So again, Abbott Mourly logo. General is going to be the Smith Family Trust. So let me go through, and as I go through this, I've done a separate session on this in a webinar, but what date is the change of position? Usually these things come to us like really late in the day, is that quite often, certainly once you get the orders from the family law court, you've got a month to fix this up. Invariably it happens on the last day or so, as Tony would attest. So what day was the original deed established? Let's say what, 01, 04, 03, 2015. Now, has the trust been varied in the past post the date of establishment? So that's going to be up to you. You'll find that in the last variation. So I'm going to put no here. Are there any changes in the position in the trust? Yes, because essentially what we're doing is going to exclude Sally as beneficiary and also trustee. She's not the appointor. So yes. Do you want to change the name of the trust? And we might go yes, and I'll put that in there. So the current name of the trust is the Smith Family Trust. And, the new name is, we'll call it the John Smith Family Trust. And then what we'll do is we'll change the name again to the current date. Is there a appointor? Yes. So let's go through the trustee. So an individual. Now, importantly here, we know it's John Smith, and that's at 5 Smith Street, Sydney, New South Wales, 2000. So now we're removing Sally, but she's still, before we remove it, she is still part of the trusteeship. So we need to include her. If we don't include her, then it is null and void. Brown, I forget the one I had, but anyway, Brown Street, Manly, New South Wales, 2000. Okay, so the current appointor is an individual, and then that's going to be John Smith. You should have, I'll get our guy to add the addresses in here as well. So it's automatic. So Sydney, New South Wales, 2000. Okay, so we've done it. We've put in the appointor, we've put in the trustee. Now the changing party. So what we're doing is we can change the appointor, we can change the trustee. And remember, everything has to be in line with the trustee, absolutely crucial. There was a really good case that I looked at this morning. In fact, I'll have a look here. And I took it out of that case, which I thought was quite interesting. Let me just blow it up. This is instructive for everyone. We'll be looking at this. So this was in a case that Tony forwarded to me today. And I took a snippet out of here, and we'll be looking at this obviously at accreditation and certification course. In the recent English High Court of Justice decision in Blue and Ashley in 2017, it was noted by Leggett J. The best approach for a judge to adopt in the trial of a commercial case is to place little, if any, reliance on witnesses' recollection of what was said in the meeting conversations, and to base factual findings on inferences drawn from the documentary evidence and known or probable facts. And I think that that is absolutely crucial from our perspective, is to make sure everything is well documented. Otherwise, it ends up down in like a fight between two. And it's amazing the recollections, particularly in that case that we're dealing with, is crazy. So who's the changing party? So we know we're going to have someone who is retiring, so not be replaced. And notice how you can do it for death as well. So it's beneficiary, and it's also the trustee. So the changing party is an individual. Okay, so we've got, yeah. So we've actually got those addresses there now. So it's going to be Sally, I'll get our guy to work on this, Sally Smith, and that is 100 Brown Street, Manly, New South Wales, 2094. So I'll get him to go back and make changes to that to make it even easier. That's a beautiful thing about our system. We can change things really quickly. So we're retiring her as beneficiary and trustee in accordance with the family law court orders. Now, what we need to do is, please, what clause or rule an existing trustee provides for the change of the trust name? Remember we did that now to the John Smith. So I'm looking at it is clause 4.2. I go into the deed. What party is required? It's the trustee. Which party is required to provide their consent? And again, it's the trustee. So this is for the resignation of the trustee. And again, we're going to resign and they have to provide their consent to it. 2.1, if it's a trustee, it'll be the appointor. What clause the existing trustee provides the resignation of a beneficiary? So that's going to be the trustee, and then that's going to be 5.2. So I've got my deed there next to me. And if you've got any concerns about that, or you don't feel comfortable, please feel free to obviously contact us at Abbott Mourly, and we can do that for you. So the best way to contact Tony is just tanamoulis@abbottmourly.com.au, or alternatively, just jump onto abbottmourly.com.au and have a look there. So let's just go down and have a look at what we've got. Again, you can start to see we can do multiple resignations, multiple retirements, deaths. So this to me is your really good go-to deed of variation for changing positions. So we've got a deed of variation there. You can see here, it outlines everything. So we're going to change the trustee, beneficiary, and also name change. So we've got the trustee, John and Sally. We've got the appointor there. Changing trustee, she's retiring as trustee, and she's also retiring as beneficiary. So we've got the trustee was established by deed dated such and such. And now the rest tells about the retiring trustee hereby resigns as trustee. And remember, because we've got that clause there, the retiring beneficiary hereby resigns as beneficiary of the trust. The trust names are changed from the Smith Family Trust to the John Smith Family Trust pursuant to that clause. And then what we've got through there is we've got the signature pages. So we've got the trustee is signing, and then what we've got here is we've got the appointor signing, and then the retiring trustee beneficiary. We've got Sally Smith signing there quite separately as well. So that's how to encapsulate when we go back to our slides. That covers the case study. So the first thing, John and Sally Smith, Australian super with over 400,000 super benefits. They've been looking at property, want to use their super. You're the tax agent. And so I showed you how to use in our new establishment is to use that accountant's letter if you're not a licensed accountant. Secondly, you are the agent for their family trust of bucket companies, 400,000. You've suggested that they lend the money. So again, the trustee of the family trust, John and Sally, we would go through and we would do first an investment strategy and then that related party LRBA. And really it's all set up there for you anyway, because you can't really stuff it up because it follows Executive Commissioner's guidelines. Go and get the mortgage registered with Aventum Optimum. And now it's 2023, they're getting divorced. So we've removed Sally as a member of the Sally's a member of the Smith Family Superannuation Fund. Because it was a corporate trustee, it's perfect. All we have to do is just resign her as a director, and that's it. So we don't need to do a change in trustee. So again, the benefits of having a corporate trustee. In terms of the Smith Family Trust, they're both individuals. We went in and did a change of positions, and what we did is we removed her as both the beneficiary and also as a trustee according to the family law court orders. So that's essentially it. And as I said, next week we'll be looking at upgrading into changes of protector. But I would essentially recommend highly, and I know Tony is going to be doing a really good module in this course on the administration of estates, which is absolutely crucial in and of itself. And it's going to be worth an absolute fortune to all of you. So if you haven't registered yet, you can contact Travis at lightyeardocs.com.au. Look and have a chat with him around succession asset protection, the course. If not, you've got you can go onto Eventbrite or just simply click on any of our signatures. You'll see, for example, here, if I did a new signature there, you'll see that in my new signature there, I've got a link that goes directly to our Eventbrite. So have a look at that and then get off and running. But anyway, Tony, you got any further words at all before we close off?
No, I'm just looking forward to the module that I'm going to sort of teach.
I know you've been putting a lot of work in and actually doing a lot of courses as well around that and a lot of studies. So it's going to be an excellent session on that. We've got everything in there. I've got Karen. There's will there be another date for this? Karen, this will be the only time at this stage where it'll be me doing it live. But if you don't if you're not able to go to one day, still go to the other days. But then what happens is, and this is important for you to understand, is when we are doing the course. So the course, I'll be doing live, taking Q's and A's and live. I'm doing assessment on a live basis for you. If you can't make, for example, the second day, the 20th, because you're off doing a SMSF conference, then essentially what will happen is that'll all go into a learning module. So it's a learning assessment center, which you're going to have lifetime access to. And there's a couple of benefits of that. First off, Karen, you can come back and complete that later, then do your certification at a later stage. So you're not going to be that far out of it. Even if you're away for a couple of days, you can still get in, go back and do that. The next one, from that perspective is that you're going to have lifetime access to this accreditation and the materials, because I'll continually, and Tony will be continually updating, putting new cases, putting new resources within this learning operation, so that whatever you've got now, I can tell you, for example, when I first started doing SMSFs, can you imagine how different it is now? But you're going to have lifetime access to that. So as we change modules, you'll still have access to the new modules without any extra cost. So for me, that's a pretty exciting opportunity there as well. If you haven't had a chance, contact Travis, and then obviously, if we have a look there, contact Travis at lightyeardocs.com.au. So it's the 20th and the 21st again, Karen. What will happen after that, if you can't attend those days, the following week, it'll just take a little while, but we'll put it up online so you can then have those 14 modules at your own, you'll be able to complete at your own pace. But for the best, if you can, make sure you get it to that 3 days. Anyway, Tony and I will sign off, and next week we'll come back, and Tony's actually going to show you the letter of advice that now comes with the protector, and we'll roll out protector version 2, which will be very exciting. So later on this afternoon, you'll get a copy of this presentation, you'll get a copy of the slides, and also ASIC Info 216. Anyway, it's Grant Abbott and Tony signing off.